Court of the United States is now in session. Chief Justice Smith and Justices Gold and Eng are presiding. All those having business before this honorable court are admonished to draw near. God save the United States and this honorable court. The first case before the court today is United States of America versus John Creed.
Thank you, ladies and gentlemen. Please be seated. The case before us is the United States versus Creed. Which side is going first here? There we are. Very good. As I understand it, counsel, you and your co-counsel have divided the time, and I would gather you're going to help keep track of the time. So
Yes, sir.
please proceed. Identify yourself for the record.
Chief Justice, and may it please the court, my name is Jeremy Rill, and along with my co-counsel, Christina Hartman, we represent the petitioner, the United States of America. Ms. Hartman will discuss the two issues under the federal rules of evidence, and I will discuss why collecting location information that's been conveyed to a wireless provider does not offend the Fourth Amendment. Chief Justice, may I reserve 2 minutes for rebuttal?
Yes, indeed. Would you like us to help you with that, or are you going to keep track of it yourself?
I believe the bailiff will
Okay,
handle
very
it.
good. The bailiff will help you. Thank you. Please proceed.
The Fourth Amendment protects against unreasonable searches and seizures in order to prevent police misconduct. The police in this case, however, acted both reasonably and appropriately by securing a court order prior to collecting the information. Therefore, we ask this court to reverse the decision of the 14th Circuit and hold that the Stored Communication Act is not unconstitutional for 3 reasons. First, collecting information that has been conveyed to a third party does not constitute a search under the Fourth Amendment. Second, even if it did constitute a search, it would be reasonable. And third, statutes are the best tool to protect privacy interests in the 21st
So
century.
you're asking this court to continue its adherence to the third-party doctrine. Is that part of the government's position in this case?
Yes, Your Honor, precisely because...
Well, when the third-party doctrine was adopted, what kind of records and communications did it involve?
Your Honor, the third-party doctrine comes mainly from Smith versus Maryland, where in that case the individual was conveying the phone numbers that were dialed on a telephone. But the court's
And
hold-
those were printed out on documents that people who worked for the phone company would see, right?
Yes, Your Honor.
And now, the kind of data we're talking about is generated by computers and no individual ever sees it.
That's correct, Your Honor.
So isn't there a difference in terms of disclosure to third parties between documents and information that other people have actually seen and documents and information that are both much more intimate and detailed on the one hand, and number two, are never reviewed by another human being in the ordinary course of business on the other?
No, Your Honor. If we look to the record on page 11, we can see that the privacy policy that Mr. Creed signed on to clearly states that this type of information would be collected by the wireless company. So it falls squarely in line with the precedent of Smith versus Maryland, and the third-party doctrine underlies our basic understanding of the Fourth Amendment.
But the third-party doctrine over here, of course, was crafted in a time when things were much different in society. Today, in order to function in society, you have to give information or not have access to the tools of life, it seems. I don't know how many times I've been asked to give my mother's maiden name, for example. It's not something that I want to voluntarily disclose. It's really no one's business, but it must be reposing in 100 different locations right now, my mother's maiden name. Why should we not review this over here and look to its application in modern life?
Well, even in modern life, Your Honor, the third-party doctrine still underlies our basic understanding of the Fourth Amendment. The Fourth Amendment protects what we seek to keep private, and as long as we share information with third parties, it loses that reasonable
So
expectation.
let's go a little bit beyond location data, which maybe doesn't feel as intrusive as other types of data. When we do internet searches, we're telling Google or whoever we search what we're looking for. So are the political candidates whose websites I visit, the religious institutions whose websites I visit, the news sites, maybe the entertainment sites and construe the term entertainment as broadly and as wildly as you choose. Is all of that fair game because I disclose it to Google and the government should be able to just obtain it by knocking on Google's door and say, where does Judge Gold go on the internet?
Well, no, Your Honor, because if we look to the Stored Communications Act, it draws a fine line here between content-type information and non-content information. That type of information would fall more closely aligned with the content-type information. And based on that distinction, courts such as the Sixth Circuit and United States versus Warshak have held that even emails that go through Google, for example, would still be held private, whereas the information identifying the email, the to, from line, the subject line, that type of non-content information wouldn't be subject to the same type of protections because it's been readily shared.
But in this case, counsel, the government asked for information that started some 60 days before the search, if you will, began officially. Is it reasonable to assume that a person such as Officer Creed would assume that his privacy would be basically of no relevance by going well beyond what would have even been possible before the advent of the electronic era?
Well, yes, Your Honor, because at the end of the day, all of this information is at its base, it is location-type information. So this information falls squarely in line with United States versus
So
Nance.
if let's take you, if we decided that we're going to check every place you've been in the last 365 days, can the government ask for that? Is that appropriate under the Constitution?
Absolutely not, Your Honor, because it wouldn't be relevant and material to an ongoing investigation.
But the Constitution provides that in connection with a criminal activity, there has to be probable cause if there's a search. You're asking us to suggest that that reasonable expectation is really not what counts here, that you're just saying there's no search because you have electronic data involved. Is that your position?
Well, yes, Your Honor. First, that there is no search, but to move to my second point, even if there were a search, this action would be reasonable under the Fourth Amendment. The Fourth Amendment doesn't expect a warrant in all circumstances, and at the end of the day, the final analysis is whether or not it's reasonable. As this court stated in Maryland versus King from 2013, a search is only the beginning of the analysis.
But in this case, the government relied upon the Stored Communications Act for its, if you will, warrant. It didn't even have a warrant. Does the government concede that there was no probable cause at this point to ask for the information requested?
Yes, Your Honor. The government conceded, and you can see in the record on page 24 that the government conceded that there is not probable cause in this case. But the fact that they're operating pursuant to the Stored Communications Act is what makes this reasonable.
Well, I'm sorry.
ahead.
Well, let's take this a step down over here, and that is that you concede that there's no probable cause, but in order to get an order under the SCA, you have to show something akin to reasonable suspicion. Isn't
Yes.
that so? Well, what is it that's articulated here in the record that indicates that the officers had reasonable suspicion to go back as far as 60 days in Creed's activities?
Your Honor, if you look to the record on pages 1 through 3, you can see that the specific and articulable facts include the fact that there were flyers found in Mr. Creed's police car that tied him to a hate organization, the Brotherhood of the Knights of Borum, and that as well as the circumstances surrounding the crime and testimony from his partner were all presented to the magistrate judge, who found that there was indeed specific and articulable facts, that all of these records were relevant and...
Well, but was 60 days just pulled out of the air, or is there something articulable that can justify going back that far?
Well, Your Honor, here the government's proceeding on a hate crime prosecution where it's necessary to show the state of mind of the defendant. The government believes that the participation in this organization goes directly to the state of mind of the defendant, and specifically the location records show that he has regularly been to the known meeting location of the Brotherhood, not once, not twice, but on a very regular and continual basis.
Doesn't his reasonable expectation of privacy enter in here, counsel? In this particular case, you went back 60 days. My understanding of the record is that Officer Creed turned off his location, if you will, device on his iPhone or whatever phone he had. Does that make any difference in this case?
No, Your Honor. Under Katz v. United States from 1967, Justice Harlan famously wrote that a search occurs when there is both a subjective and objective expectation of privacy.
Okay, in this case, clearly by turning it off, he thought he was not going to have that information revealed, did he not?
Well, no, Your Honor. Even if we look at the 11th Circuit's decision in United States versus Davis from just last year, the court recognized that the average cell phone user should recognize that the way cell phones operate, they're necessarily communicating their location to the cell towers in range. And indeed, in addition, Mr. Creed explicitly agreed to the privacy policy in this case.
But doesn't that go to what my colleague just mentioned earlier? That is, does a person have to, in effect, go into a cave, turn off a cell phone, and have no modern communications at all in order to get privacy in this time?
Well, no, Your Honor, but still, even if he had a subjective expectation, under the third-party doctrine, when we're sharing this type of non-content information in order to be provided with a service, Mr. Creed's weather app was providing him with
Well, you speak of non-content, of course, you're referring to like the difference between the content of a phone call, but when you locate where a person is every hour of the day for 60 days, that tells a lot. There is content there, is there not?
Yes, Your Honor, but we're necessarily giving that information up, and that falls in line with United States versus Knott's. Although we might want to keep our location private, when we walk outside the front door, we're giving it up.
Does a subjective difference make a difference? In other words, if he thinks it's private, does that make a difference?
Well, no, Your Honor, because even if he had a subjective expectation of privacy, it wouldn't be objectively reasonable in light of this third party.
What if he wrapped his phone in saran wrap and he thought that protected it? Would that make a difference?
No, Your Honor, because it still wouldn't be objectively reasonable that this information is not being transmitted. The privacy policy, the way his phone operates, the fact that the apps are giving him location information, all shows that this information is clearly being conveyed to a third
We
party.
can agree, Counselor, can't we, that Congress cannot pass a statute that provides for searches and seizures that would otherwise require a warrant under the Fourth Amendment without one, can't we?
That's correct, Your Honor.
So how does the Stored Communications Act possibly save this if we disagree with your argument about the third-party doctrine and say, as we've previously suggested, it doesn't apply anymore in this kind of context?
Because, Your Honor, the Congress is allowed to go above and beyond what the Fourth Amendment provides and give additional privacy protections to the citizens, and that's exactly what happened here. Based on this Court's precedent of the third-party doctrine, this type of information is just not subject to Fourth Amendment protection.
What I'm saying is if we reject the third-party doctrine in our analysis in this case, is there any way to save this information from the petitioner's point of view? Or doesn't it fall outside the Fourth Amendment because the SCA is nothing but a congressional end run around the probable cause requirement for search and seizure?
No, Your Honor, and that takes me back to my second point, is that even if this Court were to reject the third-party doctrine and find a search, this search would still be reasonable under the Fourth Amendment. In Terry v. Ohio from 1968, this Court recognized that we can find the reasonableness of a search by balancing the privacy interests at stake with
Are
the
you analogizing 60 days of location data to what happens at a stop and frisk under Terry?
Yes, Your Honor. The analogy is certainly well put because in a Terry stop, there's a great intrusion on the person of the individual involved. Here, there's essentially no intrusion on Mr. Creed's life.
But,
like a
counsel,
Terry
hasn't the
stop.
Supreme Court just recently radically limited the extent and timing of a Terry stop?
Yes, Your Honor, but the point remains in that when we're looking at the search at hand, we can still balance the interests at stake.
And hasn't the Supreme Court also just recently held that a search incident to arrest has got to be looked at differently when something as data-rich as a cell phone is involved in it?
Yes, Your Honor, and the government doesn't dispute that the contents of a cell phone under Riley versus California would certainly be protected. But when we're dealing with the location information that's been conveyed, the privacy interests that are at stake are just not the same. They're much lower in light of the third-party doctrine.
You know where a person goes to church, you know where, or whether he does or not. You know if a person is having an affair or not. What kind of private things can a person do in his life or hers that wouldn't be revealed by 60 days of location data, as precise as what's at issue here? We know what motel he stayed at and what nights he stayed there. We know who he socializes with at night, and if the government's theory is correct, we know that he belongs to a hate organization and attends its meetings. What could be more intrusive?
Yes, Your Honor. However, law enforcement is capable of getting that same information just by following him out on the streets.
Then why didn't you?
Because we couldn't go backward in this case to get the 60 days.
And
that-
therein lies the rub,
Yes,
right?
exactly it, exactly.
Yes, Your Honor, but it also goes to the privacy interest at stake. We're not dealing with what the court worried about in the concurrences of United States versus Jones, like warrantless current tracking of an individual.
But if you looked at the phone records here, as my colleague has alluded to, you can piece together his entire life for that period of time. I don't think there's anything that was omitted there. We have the time he went to work, we have the number of hours he stayed at the Shady Motel or whatever that was, in addition to other details here. So we're talking about a dragnet, so to speak, aren't we? We're talking about invading every aspect of someone's privacy.
Well, no, Your Honor, because the information has already been shared with the public. Law enforcement could get this type of information by following people on the street.
But as each of us has suggested here, before the advent of this kind of geolocational data, you could have tracked someone with a warrant, or perhaps even without a warrant moving forward. But in this setting, you're moving backwards in time before the investigation even starts. Say you had somebody that was on a parole, and they weren't supposed to go somewhere, and you look at this information and you convict them by virtue of the location. Would that be lawful?
Your Honor, if following the guidelines of the Stored Communications Act, then yes. That fact makes
What about
this-
the Constitution, counsel?
Your Honor,
What about the Fourth Amendment and the requirement of probable cause?
the Stored Communications Act is what makes this reasonable. Chief Justice, I see my time has expired. May I briefly?
We wouldn't want you to run over your time, but thank you very much, counsel, for your presentation.
Thank you.
Chief Justice, Your Honors, and may it please the Court. My name is Christina Hartman, and as my co-counsel stated, I too represent the petitioner, the United States of America. To ensure fairness and effectiveness in the truth-seeking process, trial courts must respect long-standing precedent and legislative rulemaking when ruling on the admissibility of evidence. We therefore ask this Court to reverse the decision of the 14th Circuit and find the evidence admissible for two reasons.
Which evidence are you talking about?
Your Honor, I'm talking about the declarant's dying declaration and the ancient document found on page 16.
Go ahead.
Moving to the first point, first, courts may not ignore this Court's consistent pronouncement that a dying declaration does not violate the Confrontation Clause of the Sixth Amendment.
But it really hasn't said that. All we have said is, in dicta, we've indicated that that is not before us in Crawford and some of its progeny. We've left this as an open issue, have we not?
Yes, Your Honor, this Court has left it as an open issue because dying declarations have not been before this Court. However, in Crawford v. Washington in 2004, this Court said that the right of confrontation is most naturally read as a right to confrontation at common law, admitting only those exceptions that have been established since the time of the founding. Justice Scalia stated in a footnote of the majority opinion that those exceptions that have existed since the time of the founding, namely dying declarations.
Is there any reason to admit this statement other than the fact that some courts would have admitted it 250 years ago?
Yes, Your Honor. Aside from the precedent of this Court, also the fact that the situation before this Court today, where the declarant's dying declaration is at the hand of the defendant, is exactly why we have always had this exception. If we look at what Justice...
Well, but times change, of course, and that is there's probably less adherence to strict religious doctrines and principles than there had been in the past. I'm talking about in the United States in general. Now, shouldn't we be aware of and mindful of the changes here in our societal outlook? Of course, so much of the basis for the dying declaration was, of course, the belief that nobody would want to see their maker with a lie on their lips. But today we have all kinds of shifting standards in religious adherence.
Your Honor, it is true that dying declarations originated in a more religious society, and that society today is more secular. However, there has never been a religious requirement in order to admit a dying declaration. There has never been a religious litmus test for
And what's the
admissibility.
logic of it? Why should we have this rule? What sense does it make?
Your Honor, the reason why we have this rule is for two reasons. One, because we as society have always recognized this, not just since the time of the founding, but a century before, and because there are factors in equity, which is why we have always allowed it. But if we look at the exception, this court said in Crawford that those exceptions that have existed since the time of the founding, and this court has consistently said that, not just in Crawford v. Washington, but also in Giles v. California in 2008 and in Michigan v. Bryant in
So
2011.
the entire scope of your argument is that it should be the rule because it was the rule.
Your Honor, that is part of it. We cannot ignore the fact that this exception has existed for so long. As Justice Scalia said in Ohio v. Clark, most recently in 2015, this court brought the Confrontation Clause back from its grave, and we look at the right of confrontation at the time the Sixth Amendment was written, and those exceptions that have existed since that time fit squarely in line with the Sixth Amendment.
The logic of the Dying Declaration rule as it was originally crafted is, as my colleague has just pronounced, that people are more likely to be truthful when they're about to die, right?
Yes, Your Honor.
But isn't confrontation only partly about credibility and also about accuracy and ability to perceive?
Yes,
And
Your
does
Honor.
anybody argue that your powers of perception and the accuracy of your ability to recount detail is enhanced by being about to die, by bleeding to death, as in this case?
Your Honor, it's not that they're enhanced, but it is unlikely that someone is going to simply make something up. And ultimately, the final
On what do you base that, though, counsel? I mean, as my colleague has suggested here, the reality is that the brain at the time of death, particularly if you're bleeding to death, may have a far different perception of whatever reality might be than otherwise might be the case. This goes to the guilt or innocence of someone who may be completely nailed by a dying declaration. How does the dying declaration in this time of more modern medicine and so on really make any sense?
Well, Your Honor, it makes sense because of the circumstances surrounding when it is given. If we look to some of the other hearsay exceptions like excited utterances and present sense impression, the advisory committee notes state that in regards to excited utterances, in those surrounding moments, people lose the capacity to fabricate. As we can see on page 8 of the record,
They
Mr.
do? What evidence do you have of that?
Your Honor, that is found in the advisory committee notes for excited utterances.
They ever read Billy Budd?
Not familiar, Your Honor.
Okay. So basically, what you're saying is we should rely upon what the advisory committee notes say based upon, and that's what this is all about.
Your Honor, this court can certainly look to them for guidance. However, namely, in this situation where the declarant has died at the hand of the defendant, certainly cannot be ignored. Mr. Ortiz and the defendant were the only two people in that alley. And it was with Mr. Ortiz's dying words that he identifies the person who shot him. This is exactly
Let's take this situation. Officer Familia is part of the same ethnic group that was being, according to the indictment here, was being persecuted by Officer Creed.
That's
The person
correct.
who was killed, Mr. Ortiz, was also Hispanic. Why are we to believe that the Officer Familias would tell the truth about what Ortiz said, given the fact that even though he was called, in quotes, one of the good ones, in quotes, by Officer Creed by his own statement, why are we to believe that his testimony is credible without an ability to cross-examine?
Well, Your Honor, Officer Familia's testimony could ultimately be questioned at court. And those types of
But
questions...
it's what he said about what Ortiz said that I'm worried about, not what Familias himself said. He is the recorder, if you will, of the dying declaration, and yet he is part of the same group of people that were allegedly the subject of the hate crime of Officer Creed. It's inherently subject to some concern, is it not?
Yes, Your Honor, and those questions ultimately go to reliability. When it comes to dying declarations, we have never taken into account those types of factors. We look at whether the person believed that they were imminently dying and whether they made statements regarding the causes and circumstances surrounding their death.
Some of the rationale for the Dying Declaration is that there's often no evidence other than the Dying Declaration to tell us what occurred.
Yes, Your Honor.
But in this case, we know that it was Creed's gun that shot Ortiz, and we even have videotape of part of the interaction between Creed and Ortiz. So the only thing that the dying declaration adds is culpability for that interaction that's not intuitively obvious from the fact that it was Creed's gun and from what appears on the videotape, or at least might arguably not be intuitively obvious from what appears on the videotape. For some, it might well be. So this is not a case where there is a dearth of other evidence and we need the dying declaration to have any inkling about what happened. We have a lot of evidence about what happened. Maybe this is the wrong case to test.
And further to
the
what my
viability of the
colleague
dying
just
declaration.
mentioned, Officer Creed indicated that Ortiz had a firearm. It is true that there was no firearm found, but the video recorder was a shiny metal object, right?
Yes, Your Honor.
So that arguably a defense lawyer could claim that he thought, that is, Creed thought, that the video recorder was a firearm. We unfortunately deal with these kinds of cases on a regular basis, particularly in connection with whether or not there's qualified immunity. So to further to what both my colleagues have indicated, isn't the dying declaration really something that after Crawford should be highly, highly suspect unless there's further reliability to what was being said?
Well, Your Honor, again, the reliability question goes to the jury. And whether or not there were other evidence, there's other evidence available, the dying declaration analysis should be the same. And as I mentioned previously, this court has consistently maintained that society recognizes this exception.
Well, the dying declaration has always been very, very limited to homicides. Is that correct?
Yes, Your Honor, that's
All right,
correct.
and there has to be a reason why it has historically and statutorily been limited to a single category of crimes. Now, why do you think that might be? Why do you think it's limited to homicides when you have all manner of heinous crimes? Why is it limited to that, would you say?
Your Honor, I think it's limited to that based on, the logic of it being in equity, and that at common law, it was where the declarant died at the hand of the defendant, which is exactly what we have in this case, and why the dying declaration should be admissible.
Well, of course, in times past, there was very little in the way of forensic tools to assist, and that is before the time of DNA, before the time of fingerprints, before the time of ballistics evidence. So I guess you had to have something to prosecute someone on, and I suppose the victim's statement there. But the point is that, it's a very, very narrowly construed area, and isn't it time that we review it and that we finally discard something that really has no applicability today?
Your Honor, the dying declaration has been expanded far beyond what it was at common law, and if this court wanted to limit it to what it was at common law, that would fit squarely in line with what happened in this case. But moving to the second issue in regards to the ancient document, this court should reverse the decision of the 14th Circuit and find that the document on page 16 of the record was admissible because judges cannot follow the law and then add in an additional reliability requirement.
Isn't it a trial judge's basic function to determine the reliability and the integrity of the evidence that's presented to a jury while they're supervising a case? Don't we look to trial judges, for example, under Daubert, to be gatekeepers of what expert testimony can be received?
Your Honor, the judge is the gatekeeper, but we also need to make sure that we are realizing what that gatekeeper function is. It is to follow the federal rules of evidence. And what the judge did in this case was find that every element of the rule was met and then graft on an additional reliability requirement.
Let's just say hypothetically that what was found, there was a National Enquirer article that met the 20-year rule and it mentioned Officer Creed. Would that be entitled to the same type of treatment that you're asking us to apply here?
Well, Your Honor, evidence, first of all, has to be relevant. But then if it
Well,
did...
let's just say that it said that he was a member of this racist group.
Yes, it could be.
Would we be able to rely upon the National Enquirer article without exploring whether National Enquirer had a reputation for integrity in articles and so on?
Your Honor, the ancient document rules do not require reliability within the rule. Other rules do. If the Advisory Committee on Evidence rules had wanted there to be that reliability requirement in there, they could have added that into the rule itself. Chief Justice, I see that my time has expired.
Thank you very much, counsel, for your argument. We'll now hear from counsel for Officer Creed. Please proceed, counsel.
Good afternoon, Your Honors, and may it please the Court. My name is Alex Thomason, and I'm here today on behalf of the respondent in this matter, Officer John Creed. Today we ask that this Court affirm the ruling of the 14th Circuit and hold that 1, the Fourth Amendment protects Officer Creed from the government's warrantless collection of 60 days' worth of geolocation data, 2, that ancient documents must bear some additional indicia of reliability before the statements contained within them may be admissible for their truth, and 3, that Officer Creed has a right under the Sixth Amendment to confront a dying declaration made against him.
It's interesting to me that you mentioned the 60 days, counsel. I'd like to give you a hypothetical. Assume there's a bank robbery, and assume we have reasonable and specific facts suggesting that someone perpetrated that bank robbery. And assume the government under 2703D asks for the cell site information of that person during the 30 minutes surrounding when that bank robbery occurred. Has that individual's Fourth Amendment rights been violated?
In the context of an inquiry where it's limited to 30 minutes, yes, it still would be violated, Your Honor.
It would be.
Yes, that's correct. And that's because of the means that's used to acquire this information. It's quite a bit different, as Your Honor has recognized during the petitioner's argument, from what has traditionally been allowed under, for instance, United States versus Knotts in the context of visual surveillance. In the first instance, of course, there's no real way that they could have actually visually observed Officer Creed during the months of August and September of 2013 from the starting point of January 6th, 2014, which is the time at which they first expressed interest in this information. And so to the extent that perhaps in your hypothetical, Your Honor, that there was a 30-minute visual surveillance or a day-long visual surveillance, as in Knotts, that would be perfectly fine. But it's also worth noting that in Knotts, all that the court held was that one trip was admissible, and it actually explicitly reserved the question of what we would do if we encounter this type of issue, this type of dragnet surveillance. And that's what we're faced with here today, and this court should find that Officer Creed does have a reasonable expectation of privacy in the data that reveals all of his public movements over the course of a 60-day period.
Well, under the SCA, there still is a requirement, of course, that the officers applying for the orders articulate a reason for doing so. Now, is there anything in their application, in their articulation here that falls short? I'm just thinking about what we have here. We're not talking about just simply a homicide prosecution. We're talking about a hate crime. And hate crimes involve usually more than just, an act. It usually involves the actions of a perpetrator before and after, because you're talking about a mindset more than just an individual act. So how would you address that?
Well, I would address that from the point of view of looking at what the Stored Communications Act actually does and looking at some of the problems within it in the first instance. It may be the case that here that they did give specific and articulable facts, but none of that's ultimately going to matter, as this court has already noticed, if it is the case that as applied to this type of information, the Stored Communications Act is unconstitutional. There are a couple of suspect attributes in the first instance to the Stored Communications Act. Most notably, it doesn't at any place provide a remedy. So if it were the case that there were not specific and articulable facts, or that the law enforcement officers in this case...
That's not this case, counsel, is it?
No, Your
We
Honor.
have enough to talk about.
Sure. Moving on to the other reasons why the Stored Communications Act is suspect. The premise of that doctrine is ultimately that this type of information, this type of digital data, is the type that has historically, under the third-party doctrine, been treated as having an expectation of privacy below the line of that which is reasonable.
Let's talk about that expectation of privacy. Officer Creed is, by definition in this case, a police officer. He's been involved, according to the record, in some investigations before. He seems to understand a lot of things about how electronic media works. He knows enough to turn off his location button. What reasonable expectation of privacy could he have? He's not a dummy. He understands how these things work. Can a person be granted, if you will, a right of privacy when no reasonable person can believe that he, in this case, reasonably believed that there was any right of privacy?
So, Your Honor, that would be assuming that there's not an objectively reasonable expectation of privacy in this information. So, as you mentioned, he did, in fact, turn off the location services showing his subjective expectation of privacy. So when we look at it in the context of objective expectations of privacy, the question then becomes, what are the widely shared social expectations with regard to this type of data? And of course, that's a very difficult question to answer. It's hard to know exactly what society expects. We can't glean from some lower court decisions and from some legislative acts.
We can glean from common sense, because today we know that when we go on the internet, we are going to generate ads being pushed at us based upon our internet searches. We know that as we travel, our restaurant apps and our map apps are going to tell us how to get around on mass transportation, where we can rent a car, and where we can have a nice night in a hotel. We know if we buy one book, Amazon is going to tell us which other ones we might like. So haven't we, by engaging in the internet marketplace and the internet exchange of ideas, surrendered rights of privacy that might have seemed reasonable 25 years ago? And isn't there a new definition of what's a reasonable expectation of privacy? I can find people's baby pictures on Facebook now if I want to, right?
Yes, Your Honor, you could, but it is worth noting that in the context of somebody posting a baby picture on Facebook, or in the context of someone doing a Yelp search or an Amazon search, they really are taking more of a step to not preserve that information as private. And that's really the distinction here. So in terms of the third-party doctrine, and getting back to that point, the court really did make a movement or take a step away from the applicability of that doctrine in Riley versus California, handed down just 2 years ago. And of course, the circumstances in that case were slightly different. There was a lot of information at stake, and arguably there's the rationale that the law enforcement officers intruded on the effect. But it doesn't change the fact that the broader message from that opinion was that digital data and cell phone data as a category implicates different privacy rights.
Well, does it really? Why is a geolocation point of data any different than a pen register point of data? What you got before was an ability to know what phone number was dialed. You know, they can trace who owns that phone number. In this case, it shows that you passed certain cell phone towers that are located in a particular place. Why is the pen register any different than what happened in this case? Not going all the way to what my colleagues have talked about, which is a much broader issue, but just in this case, why is the geolocation data any different than a pen register?
Because what the pen register really shows is exactly who the person called, or rather really just the number that was dialed. The information in this case, the public locations, shows a lot more and a lot of
maybe it doesn't. If in the days of landlines, when people used those pretty much, you could find out very easily through the same means who owned the phone and where the phone was located, right? It wasn't moving around. So what's the difference between that and the location of a cell phone tower?
Well, what you pointed out, Your Honor, is the difference. The cell phone does move around. The cell phone goes to different places. So the cell phone inherently ultimately ends up telling you more in terms of than what ultimately a pen register would. But moving back to this question on the third-party doctrine, because since it was moved away from in Riley versus California, it's no longer a dispositive rule.
Do we have to abrogate the third-party doctrine in order for you to prevail in this case?
No, Your Honor, you do.
How does it survive and your position prevail?
Well, what we really need in the context of the third-party doctrine is a limiting principle. And what that limiting principle could be, and what Officer Creed suggests it should be, is that when the person retains a subjective expectation of privacy, as was the case here, the third-party doctrine shouldn't eliminate the reasonableness of
So if I send my good friend an email, and I have a subjective belief that my friend will keep that email private, and that friend decides that when a police investigator comes knocking on the door and asking if he's received email from me, to show it to the investigator, my subjective expectation of privacy in that email communication should keep my friend from being able to turn over that email to the police officer?
Not quite, Your Honor, because
Isn't that the third-party doctrine in an individualized sense?
yes, but it still wouldn't be the case there, like the defendant in Katz and like Officer Creed here, perhaps, that when you sent that email, that you took steps to preserve that information as private, or that...
Oh, part of my email communication was, hey, pal, don't share this with anybody. This is between us.
If you took that step, there would still be the inquiry of whether or not you truly did have a subjective expectation of privacy. When a person really goes out of their way to shut off the location services operation of their phone, they are truly saying, I don't want my phone to communicate digital information or send transmissions automatically and continuously to a cell site data that then my cell phone company, A, B, and C Wireless, ultimately ends up collecting for the government to be able to go to acquire so easily. And that really is a big part of this case. Think about how difficult it would have been pre-digital and pre-technology to obtain 60 days worth of someone's movements in public.
Well, technology is, of course, at the heart of this, but I think we're losing sight of the fact that the phone itself, of course, is the instrument that is giving out all this information, but we really don't know who is possessing a phone at any given time and who's actually doing these communications. Is that correct?
Well, you can infer pretty easily that
Well, you can infer. For example, in my own household, we have 4 phones on the account, and they're all in my name. And 2 of the persons who have the phones are out of state right now. So you collect that data over there. It's going to, reveal that, I'm doing things, all over the place when I'm really not. I only have one of the phones over there. The point that I'm making is that you're talking about an age now where you have to avail law enforcement of the tools to investigate now that they have to be able to deal with scenarios and fast-moving events that didn't exist before. And don't you think that the government should be able to engage in the dragnet, so to speak, in order to overcome some of the other issues that I raised here? You don't know what we're talking about necessarily. I've had cases in which the person that had the cell phone was not the person who was the registered owner.
Yes, Your Honor, and that may very well be the case. But ultimately, if it is someone else who's walking around with the cell phone, then that would mean, if it was, for instance, in this case, that Officer Creed didn't have the cell phone and it was someone else, then that would make the information irrelevant from the first instance.
Well, the whole thing is that it has to be relevant and material to an investigation. That is the standard.
Yes.
Yeah, all right.
But addressing that second question, Your Honor, and I want to make sure that I am addressing it correctly, this idea that law enforcement officers should be able to use the best available techniques to prosecute a potential criminal defendant.
Well, certainly to investigate and
Yes.
ultimately prosecute, yes.
Yes, well, and of course they should be able to, but they shouldn't be able to without some type of check, and the warrant requirement is exactly the check that is needed for this type of information.
Counsel, I take it if Mr. Creed wanted access to his cell site location information from his service provider, there'd be no constitutional impediment to him obtaining it, correct?
If he wanted the information himself, that's correct, Your Honor.
And he could then offer it as evidence in his case, in his defense, correct?
To say that he was somewhere else at a different time?
Yes.
Yes, Your Honor.
So let's posit the following. Let's say the government has an informant that says Creed is a member of the Brotherhood. The informant refuses to testify. Creed hears about this. He wants to disprove it. He takes 10 days when he knows he was away and didn't visit the Brotherhood, and he produces those 10 days of data. Is it your position that the government is precluded, absent a search warrant, from getting the other 50 days of data to refute the contention that Creed is able to make based upon the 10 days of data he produces.
Yes, Your Honor. Of course, Officer Creed is able to introduce evidence that would show his innocence. And that really is all that we're asking for here, is the search warrant to get the rest of the information, if the law enforcement officers in this case did in fact want to tell the rest of the story. And there is a really good reason for that, Your Honors. When we look at this CAT standard and we look at what an objective expectation of privacy is, as I've already stated here today, the question is, what are the widely shared social expectations? And during the oral arguments in United States versus Jones, a case somewhat similar to this case here, Justice Breyer opined from the bench that one of the ways in which we can tell what society expects is by asking the reverse question, which would be asking, what does society look like when law enforcement officers are able to take this type of information with limited, really it's cost-free to them, they can do this so easily. And what does that society look like? It looks like a society full of people who can't safely or feel secure moving from point A to point B without it later being discovered that they did make that movement from point A to point B. It limits people's expectations of privacy in their movements solely to inside of the home. And that is inconsistent. I see that I'm out of time, Your Honors. A brief second.
I want to ask one quick question, Counsel.
Certainly.
What case do you rely upon? What's your best case for the fact that what occurred in this case was a search under the Fourth Amendment?
Taking together the various concurrences of United States versus Jones, and though there was that issue there of whether there was the physical trespass, which was ultimately the grounds on which the court decided, this court's oral arguments quite clearly show that the real question there was, what is the reasonable expectation of privacy? And 5 justices on that court found in various concurrences that there would be one in public movements of this
So
nature.
Jones is your best case?
Jones in conjunction with Riley, yes, Your Honor. For the foregoing reasons, we respectfully request that this court affirm the ruling of the 14th Circuit. Thank you, Your
Very
Honors.
good. Thank you, Counsel. We'll hear next from last counsel on the docket today. Please proceed, Counsel.
Good afternoon, Your Honors, and may it please the Court. My name is Sarah Ullman, and I am also here on behalf of the respondent in this matter, Officer John Creed. Today, we ask that this Court affirm the ruling of the 14th Circuit and hold that, first, this Court should not permit dying declarations to interfere with a defendant's right to confront all those who act as a witness against him as guaranteed by the Sixth Amendment of the Constitution. And second, that litigants cannot introduce untrustworthy documents pursuant to the ancient documents exception without first demonstrating their reliability.
Counsel, as you well know, on the ancient documents score, that is a federal rule of evidence that's been gone through the normal process and indeed approved by Congress by failure to act. That is a rule of law. What authority does the district judge have in this case to ignore express rules of evidence and just go on the reliability issue?
Well, Your Honor, the judge was not ignoring the rule of evidence. As Justice Gold stated, it is a fundamental function of the trial judge to ensure that unreliable evidence is not being placed before the jury.
And what part of the rules of evidence do you cite for that in connection with the ancient documents rule?
We cite Rule 102, Your Honor, under which the rules of evidence state that the rules of evidence are to be considered as a cohesive whole and not considered in isolation. And
So anytime a federal trial judge says, these rules of evidence are nice, but they're not quite tight enough for my courtroom, I'm going to impose some extra requirements here. With respect to any rule of evidence at all, any trial judge can do that at will.
Your Honor, the trial judge may do that if the trial judge finds that applying a rule by its letter would interfere with its underlying intent, with the purpose of the rule. And that's what the judge found in this case.
Isn't that lawless?
No, Your Honor, because it is giving effect to the purpose, as stated in the rules of evidence, to ascertain the truth and reach a just determination.
Why isn't Rule 403, which asks courts to look at the prejudicial value and probative force of evidence before permitting its introduction, sufficient to attain that goal without allowing trial courts to manipulate the federal rules of evidence to allow in what they want in and keep out what they want out?
Rule 403 is there, Your Honor, in a particularly egregious circumstances, but the applicability of that will be very rare, meaning that there will be a gap between...
So we don't have a case here where the prejudicial value outweighs the probative force of the evidence.
No, Your Honor. The court did not apply that in this case. However, the court reasoned that, nonetheless, there was sufficient reason to think that this document was untrustworthy and that it would violate the general purposes of the rules of evidence to put this unreliable document before the jury.
But shouldn't that go to the jury, the reliability issue? I mean, they could say that this guy didn't sign it, the head of the order, there's no evidence that it's his handwriting, et cetera, et cetera, et cetera. Why wouldn't that type of evidence, going to the reliability of the document, be the appropriate way to handle it, rather than excluding the document in its entirety?
Well, Your Honor, juries are there to evaluate the credibility of a document, to determine how much weight that document should be.
Well, that kind of goes to the point. Shouldn't the jury be weighing the weight of the document and its reliability rather than just excluding it so the jury never hears it in the first place?
The jury may weigh credibility. However, if the document is unreliable, it is within the province of the trial judge to exclude that document.
Well, but Congress, in its wisdom, formulated a rule of evidence that appears to permit such a document to be before the trier of the facts. And I think that there isn't a court that does not recognize the wisdom and the ability of juries to get at matters over here. Now, is there anything that you said in making your points that could not be argued to a jury regarding credibility and weight? And that is, leave it to the trier of the facts. Is there anything that you've brought out here that could not be argued before a jury? It might be very persuasive regarding that.
It's not that it couldn't be argued to the jury, Your Honor. It's the question of whether it should be placed before the jury at all. And with this document, the trial court concluded that it should not, because it has not, there has been no corroborating evidence to demonstrate that the individual who the government
Well,
claims.
that's something that's been engrafted, that the court below engrafted upon this, in this situation. There is no requirement of a separate showing of reliability, is there?
Well, Your Honor, the trial court concluded that it was implicit within the rule, because throughout the advisory committee notes, particularly in the sections on hearsay, it's made very clear that the legislature recognized that hearsay is generally unreliable. So it's implicit within each of these hearsay exceptions that the evidence that is introduced pursuant to them be reliable.
Let's take a look at another hypothetical. Let's imagine that instead of this document about John Creed's commitment and involvement in the Brotherhood, the document was more than 20 years old. It expressed John Creed's commitment and involvement to the organization, but it was a civil liberties organization. It was an organization that was fighting for the rights of Hispanics in Boerum to be accepted, and it was Mr. Creed who was offering that document in evidence. And the court, in its discretion, decided that that document was insufficiently reliable, even though it met every precise requirement of the ancient documents exception. Should we then affirm Creed's conviction when he's deprived of the opportunity to tell the jury about his civil rights advocacy in the face of a hate crime allegation, because the trial judge can't do that?
No, Your Honor, the trial court should not be permitted to do that. And the reason is that another issue in this case is that the rules of evidence must also account for the fact that they may well be used to deprive a defendant of his freedom. And that's something that we see throughout the rules, that there are additional protections for a defendant. And that's something that we've seen, for example, in the case of the public records exception, where there is an exception to that exception by which a law enforcement officer's report cannot be introduced against a defendant.
So the court should apply the ancient documents rule differently based upon whether it's the prosecution or the defense offering the document?
Yes, Your Honor, in order to protect the defendant. That is a principle that we see through the rules of evidence.
That's a startling statement, counsel.
Well, Your Honor.
What should we look to for that? I mean, basically what you're saying is the rules should be applied in the way that I think they should be applied. They have no uniform application. When we were sworn in as members of the Supreme Court, we agreed that we would do equal justice to the rich and the poor and to the criminally charged and those who were not. Doesn't that overturn the value of our oath if we're simply sliding our results around on casters depending on how we get up in the morning?
No, Your Honor. It is consistent with this court's role and consistent with the purpose of the rules of evidence to apply them in a way that is just. And what is just in this case...
Isn't just in your setting in the eye of the beholder?
No, Your Honor. The courts are still bound by the rules. The courts are merely finding an implicit requirement within the
It
ancient
sounds like
document.
you're saying that you're bound by the rules if you agree with them, but if you don't have to follow them. Is that what you're advocating?
No, Your Honor. We're advocating that each rule be applied in a manner consistent with the general goals of the rules of evidence. And that means that unreliable evidence should not be introduced. And that's what the trial court did in this case.
So, for example, hearsay is generally not considered to be reliable. There are a number of exceptions, one of which we're just talking about, that are found by the rules committees and people who have looked at this for years as being of sufficient value that they're considered an exception to hearsay. You're suggesting, I gather, that since generally hearsay is unreliable, that we should just ignore the exceptions to the hearsay rule that have been engrafted onto our law.
No, Your Honor, we are not asking this court to ignore the exceptions to the hearsay rule. We're arguing that this particular exception is susceptible to abuse, and accordingly, it was appropriate for the trial court to...
Isn't every exception to the hearsay rule subject to abuse?
Perhaps, Your Honor, but this one is especially susceptible to abuse. And for that reason, we ask that this court affirm the ruling of the 14th Circuit as to the ancient documents exception. In the interest of time, I will now move to the Confrontation Clause argument. Your Honors, in clear, unequivocal terms, the Confrontation Clause guarantees all defendants the right to confront all those who act as witnesses against them.
Well, under Crawford, we're looking at the perspective of the founders. It's rooted in originalism, I believe, the founders. Now, the founders in their time, we're talking about the 18th century, were certainly very cognizant of the common law rule as to dying declaration. It was part of the scene then, and why shouldn't it be part of the scene now? Something so time-honored and enshrined.
The reason, Your Honor, is because while a dying declarations exception may not have threatened the substance of the Confrontation Clause right at the time of founding, it does now. And for that reason, this court should not be bound to something that was appropriate.
But why is it different now than from the 18th century? What is it now that is so different?
What's different now, Your Honor, is that at the time, courts reasoned, such as in Maddox v. United States, that these statements were effectively given under oath because they were made at a time right before the individual was set to meet their maker. And for that reason, they would not lie before that, in that grave circumstance. That's something that in a society where we no longer have the same uniform religious conviction, that's not an assumption that we can rely on.
Isn't there a solemnity surrounding death, a concern about the quality of life one has led, whether or not you adopt a strict belief in the afterlife or not? Do you think people just don't care anymore at all? Or do they just care in different ways?
Your Honor, we're not disputing that there may be some level of reliability to the dying declarations statements. What we're saying is that it's not enough to infringe on a constitutional right. That right is guaranteed for all testimonial statements, and it is not appropriate to treat a testimonial dying declaration differently than any other testimonial statement.
Before Crawford, we had Ohio versus Roberts, right?
Yes.
And we had all these firmly rooted hearsay exceptions that everybody accepted were consistent with a fair trial, right?
Yes, Your Honor.
And the dying declaration exception was one of them, wasn't it? And although Justice Scalia may no longer be with us physically, his legacy survives to this extent. He directed us, he led us to the conclusion that we should be looking at an originalist meaning of confrontation, which was narrower and couldn't abide the firmly rooted exception, correct?
Yes, Your Honor.
And doesn't that import with it the understanding of what confrontation meant when the Constitution was written? How can we pick and, or are you asking us to pick and choose those parts of what confrontation meant in the late 1700s and ignore the parts that are hurtful to your case?
No, Your Honor. We're stating that the case that you mentioned, Ohio v. Roberts, this court abrogated that case, and recognizing a dying declarations exception essentially goes back to that approach, because it concludes that because a dying declaration is sufficiently reliable, it may be admitted even though it violates the plain terms of the Confrontation Clause right. And that's not appropriate following Crawford. Crawford stated that The Confrontation Clause right is not about ensuring that only reliable evidence be admitted. It's about ensuring that reliable evidence be evaluated in a particular way by cross-examination of all declarants of testimonial statements against the defendant. And also, this court does not have to be bound by principles that were appropriate 250 years ago in order to be consistent with the founders' intent.
I take it you're not an originalist.
I am an
Not all
originalist
the
in
time.
spirit.
Okay, yeah.
And the originalist analysis should focus on the spirit of the right that was intended. And
But isn't the essence of that argument, though, that it's how it was understood at the time? And can't you find, if you pick through the cases, pretty much what you can find in anything in the law? You can find whatever you want to mean whatever you want.
Perhaps, Your Honor, but we know that the right of confrontation is meant to be a right for defendants to cross-examine witnesses
Well,
against
that's,
them.
as my
Well-
colleague just pointed out, this is what Justice Scalia's strong belief, who now has had his own dying declaration of which we know nothing. And the reality is, we don't really know much at this point until we decide how far Crawford goes, do we? It certainly changed our construction of the Confrontation Clause, did it not?
Yes, Your Honor, it fundamentally changes the construction of the Confrontation Clause, and it changed it in a way that dying declarations should no longer be admitted, because the justification that the petitioner mentioned for the dying declarations exception are no longer relevant following.
But Crawford dealt with lab results, did it not? What do lab results have to do with the dying declaration?
Well, Your Honor, Crawford did not deal with the dying declaration specifically, which is why this court is not bound by its statement in a
Don't
footnote.
the facts of the case make a difference? Can we just pick something out of the verbiage from the court and make it mean whatever we want?
No, Your Honor, we're not asking this court to make this statement mean
Well, that's
whatever.
one of the dangers of relying too much on dicta, right? And that is just picking out what you want, right? It's not part of the holding, of course.
Yes, Your Honor, this court should not be relying on dicta, and the only time that this court has spoken of dying declarations has been in dicta. It has never held that there is a dying declarations exception. All the cases, Maddox v. United States, Carver v. United States, these were all speaking in dicta. And furthermore, they were relying on justifications such as reliability and necessity that this court stated in Crawford are not part of the analysis anymore.
But I gather you want us to make new law. You recognize that, right? There is nothing that our court has said that completely corresponds with what you're saying. You agree with that?
I see my time has elapsed, Your
You
Honor.
can answer
May I?
that.
Your Honor, we are actually asking this court to be consistent with the holding in Crawford v. Washington, that this is a right that is guaranteed to all defendants for all testimonial statements, and dying declarations should not be treated any differently than any other testimonial statement.
So you're
Thank you.
advocating for truth, justice, and the American way.
Always, Your Honor,
Of course.
yes. Thank you.
Thank you all. Please, counsel. So I understand you have 2 minutes, is that right?
2 minutes,
Okay, very good.
Chief Justice, and may it please the court, I have 2 points on rebuttal. With regard to the ancient document exception, counsel for respondent agreed that all evidence weighing on the reliability could be argued to the jury. Congress determined that evidence that met the ancient document rule should be admitted to the jury and allow the jury to make their own conclusion about reliability. Any changes in the rule should come from Congress and not to be applied differently to different parties. And with regard to the Fourth Amendment, counsel for respondent argued that this court should limit the third-party doctrine in situations where there's a subjective expectation of privacy. But that would destroy the reasonable expectation of privacy standard that comes from Katz. It would allow criminals to define the expectation of privacy based on their own actions and concealing their activity.
But if in fact, a reasonable expectation of privacy is at the base of Katz, isn't that in fact what you would have to do, is to look at the actions of the defendant to determine whether the expectation was in fact reasonable? If it was gamed, it wouldn't be reasonable, would it?
Certainly a subjective expectation, but this court should not ignore the objectively reasonable prong of the Katz analysis, and with particular light to the third-party doctrine. This court should affirm the vitality of the third-party doctrine because it underlies our basic understandings of the Fourth Amendment. Thank you.
Okay. Do we have other rebuttals, or are we all squared away? Well, the court thanks all of the able advocates here. We will now recess and come to a determination, and we will return, and we will try to be reliable and not violate any
That's it,
Crawford
exactly, yeah.
If we
requirement.
can't be reliable, we will at least be original.
Incredible.
Thank you.
Please be seated.
Well, it's come down to this. Syracuse versus North Carolina.
Yes.
Villanova versus Oklahoma. No matter what transpires in the Final Four, I don't think there will be an epic contest the likes of what we just saw. And so we can really congratulate you. You know, I recently had the privilege of meeting the leader who had been retired for years of the Blue Angels Navy elite flying team, precision flying team. And on his last day before retirement, this was years ago, he told me that his commanding officer, General, had pointed to this brand-new plane. It was an advanced model of the new F-14. And he said, "This is your last day. I want you to really push this thing to the limit, see what it's got. Just go for it. Just push it to the limit." So this leader of the Blue Angels on his last day in Navy service says, "What are they going to do? Fire me?" You know, so he rode it 2.5 times the speed of sound, took it up into the space till it conked out, flew it back out, turned it upside down, back and forth, flew 100 feet above the tree levels and all this stuff. And then he landed it, hopped out, walked over, and his chief maintenance guy said, "Turn around and look what you did." And he turned around, and there was no paint on it. He had literally burnt the paint off the plane. And I think that, and it demonstrated that it was a pretty darn good airplane by pushing it to its limits. I think that all the contestants here were well served by a remarkable panel of judges who pushed our finalists to the limit and tested them. And I think in some instances the paint might have been burned off, but it was for a good purpose because it demonstrated that they're basically incredibly sound, fine lawyers already, even before they get their JDs. And so we should give them all a hand of applause. You know, some of you heard me say I tried to give up bragging for Lent. It didn't go so well. But Lent's over now anyway, so let's go for it. This contest, in its 31st year, its 4th decade at Brooklyn Law School, it reflects the best of Brooklyn Law School, and it reminds us of the heritage of one of our great former deans, the remarkable, huge intellect, capable Jerome Prince, who really stood for the height of scholarship and put Brooklyn on the map, even in early years, as being in the forefront of scholarship in the field of evidence. And then I should mention somebody who's not with us here this year, who we think of when we talk about the Prince competition, and that's Professor Robert Pittler, who was lovingly called by his many, many, many students and some of the faculty, when they thought they could get away with it, as Pitbull, Rob Pittler. He was a deeply cherished member of the Brooklyn Law School community who had a profound and lasting impact on generations of students. And he returned to Brooklyn Law School after stints at other places, including Colorado, to teach in the areas of criminal law, criminal procedure, and evidence. And, you know, his knowledge of evidence law and his expertise was encyclopedic, but much more so was his knowledge of movies and other things that he was passionate about. He was very distinguished with an article on constitutionality of New York search and seizure procedures, which was published in the Brooklyn Law Review, and it's considered the authoritative source on this subject. But it's really his extraordinary work with the Moot Court Honor Society that Bob will be most remembered by legions of students. He served as a faculty advisor for the last 12 years before he died, and for 20 years he directed the annual Dean Jerome Prince Memorial Evidence Competition. And we all know that he didn't just defer or hand out work, but he rolled up his sleeves and he got involved in every intricate detail. So, you know, we feel with his passing so close to us that it's important to remember and to honor him for carrying on this great tradition at the law school, which we are very, very proud of. But we're also thankful that that torch has been carried on by so many here, by the faculty advisor and advisors, Stacy Kaplow, Professor Kaplow, who is our dean for professional education. I've outlawed the word experiential. I don't like it, but you get the idea. That's what it's about. She has up to her elbows in every aspect of that, and really has an enormous load of things that she's working on, and took this on this year, which was remarkable. A little mashugana, but it was remarkable that she did it. Molly Falk is here, or was here. Where is Molly? She's here. She left, okay. Well, she knew I was going to speak. But just tell Molly that we gave her a shout out, please, for all her work and effort over the years. Ursula Bentley actually has a longer involvement than Bob Pittler. Right at the beginning, she started the Jerome Prince competition, so Ursula has been involved for 31 years, and you stayed involved even though you recently retired from the faculty, but we can't get her out of our hair, so that's really wonderful. And Judge Stephen Gold, who's an adjunct and extremely helpful, jumped in as an advisor, faculty advisor. You can see how well he knew the case and the problem. He was really up to his eyeballs in it. And then, of course, Professor Cameron Arnold has helped so much. So for all of you, we're enormously grateful. Thank you very much, really. Now, you'll forgive me this pride and hubris, but I just tell you all, it's just lucky that our own Moot Court Honor Society members are not participating in the competition, but they're behind the scenes, and not so much behind the scenes. There's too many to name, but Ashley Barnes, who's the Moot Court Honor Society president, and in particular Julie Melman, who's had many sleepless nights as the coordinator. Congratulations to all of you. Thank you very, very much. As to the rest of the executive board and the people who produced that video that the judges thankfully didn't see, you know, and there's so many of you, but, you know, Julia, Stephen, Katerina, Seth, I'm thinking Roman and Anthony and all the rest. Here's my advice for you. Study for the bar. You need the legal career. All right, and get good copyright counsel, okay? I won't tell, but you never know in this age. You know, nothing's private anymore. So we are really fortunate to have three extremely distinguished and dedicated jurists. And again, I'm so impressed by what they brought to the table and how much work. I mean, every one of these distinguished public servants have innumerable responsibilities and opportunities to spend time and invitations, and for them to come with us on a Saturday, but also come obviously fully prepared, and to give you an experience of what it's like to appear before a really fine panel of judges is quite remarkable. I mentioned Judge Stephen Gold, Magistrate Stephen Gold. He really has an incredible career. He clerked with the United States District Court, Judge Herbert Murray in Maryland. He was in private practice for several years, became an assistant United States attorney in the Eastern District, and ultimately became the deputy chief of the criminal criminal division in the Eastern District, United States Attorney's Office. In 1980, he left to become the general counsel for the City of New York's Department of Investigation, and then 1993 was appointed to the bench. Since 1994, he's been incredibly involved in helping us with the Prince competition, and his work has been, prodigious on top of everything else. And we're so grateful to him for being with us tonight. Steve, with us, the Prince competition and the teaching that you do, it's the gift that keeps taking. We just keep getting more and more and more from you.
It's been a pleasure.
Thank you. The presiding justice of the New York State Supreme Court Appellate Division, Second Department, which is really far-flung. So he has invitations all over the state to attend and participate. We've really been blessed by having a very close working relationship. He's conducted a court here in this very room, live courts, and he's a remarkable public servant, and that's Randall Eng, who is here with us today. He's a graduate of SUNY Buffalo and St. John's Law School. We'll forgive him for that. And prior to his current position, he's been a judge for many years in many different positions: Associate Justice in the Appellate Division, Second Department, Administrative Judge in Queens County, Justice of the Supreme Court of the State of New York, a Criminal Court of the City of New York, and after law school, he served as a military JAG Corps officer, which I think you can tell in his approach to his questioning. He was battle-tested early on in his career, and is a very, very fine justice. And we're very proud to have you here with us.
Thank you, sir.
Now, once again, we have a distinguished judge from the Ninth Circuit. It must have something to do with the fact that Ed Corman, whose portrait's on the wall, and he was here and had another obligation and ran out, he came to watch this, that Ed Corman regularly is invited to sit on the Ninth Circuit. I'm not quite sure if there's a correlation, but I think there is. But in any event, we're very proud to show our stuff, and we're very, very pleased to have such a distinguished judge make the trip here to be with us today, and that is Mylan Smith, who's Circuit Judge, United States Court of Appeal for the Ninth Circuit. He's a graduate of Brigham Young University and the University of Chicago, and his classmate is Ursula Bentley. So they have that income going for them. He was nominated by George W. Bush in 2006. Before the Ninth Circuit, he had a career in practice that was extraordinary, where he demonstrated expertise in a broad range of fields, including real estate law, corporate environmental law, and a successful transactional practice, including contract, family, tax, and administrative. So he was really a Renaissance man and one of the maybe very last of the successful general practitioners, and that's quite remarkable. So he's made his mark as a Ninth Circuit judge, and in fact, is a prolific and skillful author of majority decisions for the Ninth Circuit. One publication, The Recorder, mentioned that Judge Smith authored the most majority opinions of any judge on the Ninth Circuit between 2010 and 2013. So we're really, really fortunate to have you here as our presiding justice today. Thank you, Judge Smith. Now, bailiff, it's your honor.
Have you reached a decision?
We have, and we're not telling. Actually, we are. Before doing so, I want to mention that Justice Ang, Justice Gold, and I have felt this a distinct honor to preside over this moot court. We will give further descriptions and comments to the people that appeared before us, but we congratulate them all. We congratulate Brooklyn Law School for this excellent program. I come from a circuit where we have a lot of lawyers. Before I became a circuit judge, I had the naive understanding that all of the lawyers that would appear before us would be excellent. I'm here to refute that. But all of you could take great pride. You did an excellent job, and we would be delighted to have you come to the Ninth Circuit and appear before us anytime, and we congratulate you all. As in any contest, there have to be people who are, in quotes, the winners, but we want those who did not win the first place to know that they are fine lawyers, will have wonderful careers, and we congratulate you all. After deliberating as a panel, we have concluded that the attorneys representing the government, I think it's called Team 4, were the winners of today's contest. Do you want us to do that now, or do you want us to give comments now?
Yeah, if both teams could come up and sit in the front for comments, and then we'll hand out the awards.
We will give you brief comments. Again, we will each say something. We want to congratulate all of you. You did a wonderful job. You be very proud of yourselves. We know you worked very, very, very hard. Let me just start by making a couple of comments. In the government team's favor, you stayed within bounds. Each of these questions and the questions that were drawn up by Justice Gold and the others on the faculty, of course, were not easily answerable. They were designed to be in the middle somewhere. But we felt as a panel that the government's team didn't let us lead them off into the wrong path and got back in the right framework, get the right path. Your colleagues on the other side were very engaging. We congratulate you for the input that we got. We felt, to some degree, an appellate argument is a dance. You want to be able to dance, you want to look in each other's eyes, you want to be able to have a nice time. I don't want to use the term swinging because that has other connotations, but you were very good at that. You really were. But I think we kind of led you down the primrose path, and you got out speculating into areas that were a little more tricky, and it kind of tripped up. No big problem, but in the future, just keep in mind, if you don't know the answer, say so. Also, one of the primary purposes of oral argument is to answer the judge's questions. Most of what we learn about it comes from the briefs. So we've read what you've said before. We know what the arguments are. We know what the cases are. So when judges are asking you questions, at least in the real world, it's because we are troubled by something in your case and we want to know the answer. Now, occasionally we're trying to convince a colleague, but that doesn't happen all that often. So be sure, if you don't have a well-thought answer, say, in a learned way, I don't know. Because when you get off too far, it undermines the credibility of the other things that you've said. I think each of you, for the most part, were very good with contact with us. You came back to the subject as much as you could. You were respectful of the court. You didn't talk over the court. One of the problems that we frequently have on the Ninth Circuit is we'll get lawyers who just won't stop talking. It doesn't matter what the judges ask. It doesn't matter what they say. They just keep talking and talking and talking and talking. That's not helpful. That's not helpful. You want to answer the judge's question, but you don't want to answer more than the judge's question. It's not like a law school class where the judge is trying to see how smart you are. We're trying to understand your case. And usually there is a case. Now, for example, I noticed, and this is to some degree true of all of you, there were some key cases here, Smith and Katz and so on. None of you really wrestled much with those cases. Those were the linchpin, at least, of the electronic surveillance case. And a more frequent citation to that case or those cases and what they specifically said, perhaps even having an ability to memorize what the holding said would be helpful. One or two of you mentioned the record. That's a really important thing to do. I remember, some of you may have heard of Kathleen Sullivan. She's a partner at Quinn Emanuel. She's one of the finest appellate lawyers I've ever heard. Every other word, the record at such and such a page says, that's dot, 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 dot. Bam, that is so powerful. If you know the record and you can apply the record to the facts, it's just key. Now, there was some reference to that, but just as a suggestion to all of you, remember the record. Know the record. Tie any case that you cite to the record, because then, and there was a pretty extensive record here, it shows how it applies. I forget which one of them we asked about whether you can just pick dicta out of something. Cases, at least in my view, are tied to the facts that they come from. So if the case is about oranges and you're talking about, pomelos or lemons, and they have nothing to do with the original case, it is very marginally useful. So keep that in mind. Remember what the facts are. Try to analogize the facts as closely as possible. And like I say, as an overall comment to all of you, I think if you had analogized the facts of this case more closely to Katz and Smith and Jones and things like that, it would have been more effective. But again, I congratulate all of you. You did a wonderful job. You should be very proud of yourselves, and you should all sleep really well tonight. So, Justice Eng, you want to go next?
Yes, I do. Thanks so much. Thank you very much. I preside over perhaps the busiest intermediate appellate court in the United States. We render something like 4,000 decisions a year. And I must say that the level of advocacy that I saw here this afternoon was certainly in the top percentile of the arguments that we hear. And I say that with full knowledge that these teams have gone through a very rigorous competition. You earned your place here. There's no doubt in my mind about it. I had the pleasure of speaking with some judges in some preliminary rounds, and they were speaking of the excellence of the preparation, the presentation, and the commitment to the purpose here. And your purpose here, of course, is to develop your skills of advocacy and to put into practice the principles of law that you've learned from your faculties and from your other experiences in your legal education. I want to commend everybody on not using the expression at all, I don't believe it happened, with all due respect. I didn't hear that once, because whenever you hear that, of course, the bench gets immediately, turned up. Are they going to insult us? Are they going to say something that they'll all regret? But in any event, you didn't do that. And I commend you for the reason that the questions, some of them were very specifically targeted. That is, you were asked about a case, you were asked to something very, very specific in the record. There were other cases that were actually, for want of a better expression, streams of consciousness on the part of the judge who was asking about something and ruminating about it. But your responses, I'm talking of both teams, were very, very poised and professional. And that is, it is very easy and tempting to unintentionally give a discourtesy by just sort of blowing off what the court said. Obviously, if the judge spoke of it, it's something that's on the judge's mind in deciding the matter. So that is something that I saw here, which I don't see regularly, and that is the respect for the court and the notion that, of course, if the court is asking something, it means something. If the court is stating something, it means something. I didn't see anybody flustered by that. And that, of course, is a product of your your preparation and your confidence. That is, that you exuded a confidence which only comes with extensive preparation. If you know the cases, if you know the record, you know the facts, you're confident. I have to say that as far as the petitioner is concerned, the government is concerned, from my perspective over here, you certainly had better material to work with, I think, so to speak. You know, you're talking about dealing with the needs and requirements of law enforcement in a modern society. We're talking about technology that is over the head of everybody, actually. I have a smartphone here. I don't think I know how to use more than 5 or 7% of it, but it's a fact of life that we have to live with it. And not only that, we have the situation in our society where people are taking too much for granted, and that is that we understand that we give this information, but we also do not realize, you know, the mischief that can be done with this. So I think that, you know, your approach to this, your handling of it was excellent. As to the respondents team, in all fairness, you got hit with some, you know, very, very targeted questions that are difficult to defend in that sense. They're hard to handle, and that's recognizing you're only as good as the facts and the case law that you have. I think you did well with it. But as the Chief Justice has said over here, if you don't know something, you don't know something, and that goes to both sides. There are times when, of course, you know, the question is so abstract that you can't respond. In that it is something that does not necessarily come easily. But the gift in making an effective oral argument is, of course, doing the best with what you have and not going over the top, so to speak, and indulging in wishful thinking. Oh, if I had this, if I had that, you have what you have. So once again, I commend you on all of these points over here, and I expect to see each of you in court and with the facts that you have. So congratulations again.
Well, I'll just add a few words, given how much you've already heard, and I'll add my congratulations to all 4 of you. The participation level was excellent, and as one of the authors of the problem, I can tell you it was a lot of fun to hear how you all embraced it, understood what we were driving at, and made the arguments as well as we could have expected, really. Our Chief Justice referred to listening carefully to the judge and not interrupting. I'm a magistrate judge in a trial court. I was just glad you didn't interrupt each other, because that's what sometimes happens in my courtroom that I have to police.
Sure.
But I really do think that, by and large, you did a very good job of letting us get our questions out and responding to them. And we've made some mention about how some of the respondent questions were very tough. And the 3 of us did not know each other before we met today. And I think we developed our rhythm as we went along. And by the time we got to you, we were moving pretty good.
We're forming a law firm.
Yeah, that's it.
We're going to form a law firm.
That's it.
And I must say that however tough the questions may have been to answer, and however some of the answers may not have been as narrow as they might have been, the poise and the good nature with which those questions were taken and responded to was really impressive. And I think that deserves some special mention. I guess if I have 2 thoughts about the practicalities of really litigating in the real world, I'd say 2 things. One is, as exciting as these competitions are, they are in some sense artificial. In any real-life situation, you would have the opportunity to supplement, at least in a trial court level, and I think even on an appeals court level, if there was a question that came out of left field and you didn't answer it the way you wanted to, most benches will allow you to cure that deficiency subsequently. And so quality advocacy in the real world doesn't depend upon the ability to perform under pressure in the moment quite so much as it does in these competitions. And I guess the other thing I would say is that it is important, I think, as a real-world advocate, to think about how small a step you have to ask the court to take to find in your favor. And some of my questions, and I think some of my colleagues' questions, were directed at trying to test you as to whether you were going to advocate for the large principle that your position raised, or you were going to say, well, judges, if you want to keep the third-party doctrine, you can still rule in our favor by finding this. If you want to allow the judge to play with the ancient documents rule, you don't have to have a wholesale permission to play with the rules of evidence, because you could craft it this way. And I think that really good advocates try to get the judges to do as little departing from precedent, as little departing from what came before, to be as unadventurous as possible and still rule in their favor. And I think maybe that's one of the areas that we thought separated the teams a little bit. But again, the poise and the confidence you exude is going to stand you in such good stead going forward, and your complete mastery of what I hope was a complex and challenging problem is really, truly impressive to all of us. And if we had lawyers like you in our courtrooms every day, we'd go home at 3 o'clock and take a nap and read a novel in the afternoon.
That's what they would do in the magistrate's court.
Touche.
Well, any more? Thank you all. It's been an honor. We again congratulate the teams and look forward to seeing you in the various courts of, we're not even sure what law schools you come from yet, so we'll learn that in due course, but we'll turn it over now to the folks here.
So if you guys will just be handing out awards, if everybody could come up. I guess I don't need two of these. But, okay, so we have our first place team here and our second place team. And now for best brief, we have third best brief, Team 2, Louisiana State University. Second best brief, Team 11, University of Tennessee College of Law. And first best brief, Team 4, Stetson University College of Law. We have best oralist in the preliminary rounds, Nathaniel Koo from Team 14, University of California Hastings College of Law. And the best oralist in the final round, Jeremy Rill from Team 4, Stetson University College of Law. Okay. And now I'm, of course, going to give a very short thank you spiel to everybody who's helped me. So congratulations to all the teams for coming, for participating in all your hard work. You've done amazing. We've heard such great feedback from all the judges. Your performances have been astonishing, and we've heard nothing but great things. Brooklyn Law School really does pride itself on the challenging and exceptional reputation of the Prince competition, and everybody should be very, very proud for all the hard work that they've put in this year. I just want to say thank you to everybody without whom this competition would not have been possible, including Dean Stacy Kaplow, Judge Stephen Gold, of course, Professor Molly Falk, who had to leave early, Professor Cameron Arnold, and Professor Ursula Bentley. If you guys want to come up, we have a few gifts for all of you, please.
There you go. That's it.
Not today.
He gets more flowers.
That's it, he gets out there, where here we are, we get a water bottle. All right,
You don't think that's enough?
well, it's, anymore, I have to report that on
That's
my
right.
ethics report.
Exactly.
Thank all of you so much for your help and support in preparing for the competition. I know how much time you've all dedicated, and we really couldn't have done it without you. You've all been great these past few months, weeks, and especially during the competition, and your guidance, support, and encouragement have been invaluable, and I really appreciate all of your help. Also critical to the competition are the problem writers. Of course, we wouldn't have had any of this without you guys, and I know you've spent nights, days, weeks, months preparing the problem, the bench brief. So if you can all come up, we have something for you guys too. Mike Piancentini, Holly Protesi, Mike Troiano, Willie Smith, and Zach Kaufman, who is actually away coaching another team, so he's not here. But thank you guys all so much. Of course, Prince could not happen without the help of Beth Palastro, Chris Gibbons, and Joanne Tapia. They are integral this year and every year in every aspect of the competition, and I can't thank you guys enough, so thank you so much. Thank you to my amazing Prince Committee. You've been working incredibly hard the past few months, and you have willfully donated an entire weekend to the Prince competition, which is a huge sacrifice, especially in law school. So thank you so much. I really appreciate you guys being here. Thank you to the Moot Court Executive Board, who've been here working with me all weekend, especially Ashley Barnes, who's been my wing woman this whole time, keeping me sane and calm during the stressful times and throughout the good times. Finally, thank you to all my friends and family who have spent many late nights with me, offering advice and encouraging me. That's it. Thank you guys all so much. It's been great.
Okay, just one more thing, I promise. I will be brief because I know we all have a banquet to get to, or at least that's what I heard. But first, there's one very important person that is owed a humongous thank you for all of the work that she's put into this competition. She's been working day in and day out since day one, back at the beginning of August, on this competition, and that's our amazing Prince coordinator, Julia Melman. Now, I have worked right next to Julia, literally right next door to Julia all year long. I didn't actually know her very well when we first were put on Moot Court's e-board together, but over the past few months, I've learned that she's one of the hardest working and most detail-oriented people I've ever had the opportunity to work with. From day one, she's been on top of everything, from planning the logistics of the entire competition to corresponding with everyone, from teams to faculty, to judges, to our own Moot Court members. She has made sure that we had amazing photo ops during the course of this competition with a awesome 6-foot cell phone cut out and a balloon arch that you guys will see shortly at the banquet. And she has become an arts and crafts master of sorts, working with glue and glitter and these beads that grow when you put them in water. Something that I'm sure she would have never envisioned herself doing when she took on this position. But in all seriousness, Julia has been the backbone of this competition since the beginning, and it wouldn't have happened without all of the hours and the care that she put into it. She deserves a huge round of applause. Thank you. And that is a wrap. Thank you so much for everyone for coming out.